for our viewers, give us some perspective. What's the significance of this?
Well, the significance of this particular case, it largely depends on how significant the U.S. Supreme Court wants to make it. If they want to rule in a very broad way, if they want to use this even as the occasion for overruling the Casey case from 1992 or aspects of Roe v. Wade from 1973, they could do that. They could say that in order to consider whether the 14th Amendment prohibits this sort of law that Mississippi has passed, we have to decide whether Roe v. Wade should be overruled, whether Casey versus Planned Parenthood should be overruled. So if the court went that way, it could be an extraordinarily important case.
The fact that under the Trump presidency, it was, I mean, correct me if I'm wrong, I think you had a slightly conservative court before then, and then you have 3 more conservative justices. Should we read anything into the fact that they're even going to take this case up? I mean, should that signal something is definitely coming down the pike as far as whether it could affect Roe v. Wade?
Well, so generally when they agree to hear a case, they do so for so remember the law. So Mississippi passes a law saying that we can prohibiting abortion before 15 weeks gestation, and the Fifth Circuit, the lower court at this point, strikes it down. So they say it's unconstitutional. So when the U.S. Supreme Court hears a case, there's usually 2 reasons they can do it. 2 reasons that they do it. First, they consider cases where there's a conflict between one circuit and another circuit. And secondly, they consider a case, they grant cert because they disagree with a lower court decision. And even in the cases where there's a split between the circuits, a lot of the time when they agree to review a case, they do it because the one that they have before them, they disagree with. So right out of the box, you have to generally, if you're betting, so something like 75% of the cases that they grant review on, they end up reversing. So they end up disagreeing with the lower court. So that certainly suggests that the law. So the state of Mississippi was the one asking the court to hear the case, and when the court said yes, we will hear the case, that gives a strong indication, not conclusive, but certainly a strong indication that the Supreme Court is inclined to uphold the law.
This is spitballing on my part. I have actually heard people say that regardless of whether it's a liberal court or a conservative court, they see no way that Roe v. Wade could ever go away. That there may be some erosion of it, but that as a general rule, you know, that they don't ever think that abortion itself will ever be prohibited again. Is that wishful thinking on somebody's part?
It's hard to say. It comes down to some of the psychological questions about exactly how folks like Justice Kavanaugh, Chief Justice Roberts approach these things. So so it seems pretty clear that Justices Breyer and Kagan and Sotomayor would vote to keep Roe v. Wade. They've all indicated that in earlier opinions. And so in order to, and then we also have a number of justices who have indicated their unhappiness with Roe v. Wade and their willingness to overrule it. So it really depends on exactly how much weight justices are going to give to various interests. So Justice Thomas, for instance, says if something is demonstrably incorrect, we should overrule it. The Supreme Court should overrule it. That's all you need is sufficient clarity about the wrongness, the error of an earlier decision. Some of the other justices have suggested that there's a more complicated analysis. So one question is just how clearly erroneous are Roe v. Wade or Casey? So do they think that they're erroneous? They are errors, and if so, how clear about that are they? So there are a number of issues at stake. I certainly wouldn't say it's very clear they will not overrule Roe v. Wade, but it certainly is not clear that they will. It really depends. There's a very complicated set of considerations. When they considered it in 1992, they were considering how much people had relied on Roe v. Wade in the 19 years between 73 and 92. We have another close to 30 years of reliance interests of different kinds. So the issue about overruling in light of reliance interests, just how much clarity you might require in order to overrule something, that's a different question today. And it's difficult to know. I mean, it's difficult to know what those facts are. It's very difficult to know what the Supreme Court is going to think about those facts. They might take a while to consider the issue. They might say, well, they might have an argument about whether you can reconcile this law with Casey, and they might say, well, we're not sure about that. Let's consider whether to overrule Casey. And they could set it for re-argument. They could ask for more briefing about questions like how much the reliance interests are. They could keep the case for several years if they were really considering doing something as important and momentous as overruling Roe and Casey. But it's hard to know how they could do it. They could send it back to the lower courts to conduct some fact finding about issues that they wonder about, reliance interests, or there's different issues about justifications the court that the state has given for this law, fetal pain issues, health issues of the mother, those who regret abortions past 15 weeks, that sort of thing. So there's a lot of fact finding that they could say this would depend on, and they might say, well, it depends on certain kind of facts, send it back for the facts. We might not know how even this law is going to fare for years from now. On the other hand, they could decide it very quickly. And some people compare it to, ripping off a Band-Aid. You do it, quickly, as if they're going to pay a political cost for making certain people unhappy. Do they want to do that quickly? Do they want to consider as much additional argument as they can? Personally, as a law professor, I'm almost always at the end of June hoping for re-argument, because I almost always think there's more analysis that could be done, more argument that could be considered, more counter-argument that could be considered. But it's up to the court how much they want to do it. And they have their choice about whether to grant review. They decided to grant review in this case at this time, presumably because this is the time when they think that they say sometimes they say it has to be enough percolated. The issues have to be percolated in the lower courts enough for them to be ready to say something useful in giving guidance to lower courts about the law. So if they think it's ready, they can say what they think the law is now, and they can also take as much time as they like about it. They usually, they almost all the time, finish consideration by the end of June. So this would be the end of June 2022 that we'd be talking about. But at the end of the term, they also do set some cases for re-argument. Not every year, but it's something they can do. And in some of the momentous cases, they have even taken years. So Brown versus Board of Education, for instance, was argued at the Supreme Court, not even going back to lower courts, but argued 3 separate times. And that would be a lot for this case, but you could easily imagine them saying, we're going to set it for re-argument on a broader issue.
So the earliest we could see a ruling, you're saying, would be June of next year? Did I understand that correctly?
I would be very surprised if you saw a ruling before June of next year. The only way that it would get resolved before then would be if it was if they decided, all of the justices can agree that they need certain facts, so let's send it back for certain facts. So if they sort of various sorts of ways of punting the case might happen more quickly, but it doesn't seem terribly likely. It seems pretty likely that, the next information we'll get would be when they set the case for argument, telling us which month. October, November, December of the fall. They might wait until later. Generally, they have October, November, December, and then February, March, and April sittings of the court. And then they decide all of those cases by the end of June. Something this momentous would almost certainly they'd wait until the end of June, get it as considered as they possibly can, and maybe even ask for additional briefing, additional argument beyond that. So we'd get more information when they tell us when the argument is. Of course, the argument itself would give us a lot of information, but then the opinion itself, probably we're thinking June 2022, unless they decide they want more argument.
So I just kind of wrap this up, as a law professor, how big a deal is this?
Again, it's as big a deal. You sort of find out how big a deal it is after the fact. It is potentially an extraordinarily big deal. So Roe v. Wade is one of the three most important cases in the U.S. Supreme Court history. And overruling it would be, or limiting it significantly, would be extremely significant. If it got overruled, I think that case would immediately go definitely to the top 5 cases of all time. That would be no brainer. So I have to make careful decisions about what I include in the first year curriculum for common law. No question, if Roe v. Wade gets overruled, that's something that every single law student ought to know about.
By the way, I think everybody knows about Roe v. Wade, but you mentioned Casey. Can you explain for folks who are not familiar with that? You made reference to that.
Yeah, so Roe v. Wade in 1973 puts a bunch of limits on abortion regulations based on trimesters. So it sets up a framework that says you can't have any regulation in the first 3 months of the pregnancy. You can have regulations for the sake of the woman's health in the second trimester, and you can have regulations with a health exception in the third trimester after viability. Casey, 19 years after that, says, well, that's not the right framework. We're going to use something called the undue burden framework. So if a regulation puts an undue burden in the path of a woman seeking an abortion for a pre-viable fetus, then the law would be unconstitutional. So they changed the rule from based on trimesters. So the first trimester, so that would be 12 weeks or so into the pregnancy, 12, 13 weeks. That is no longer a critical line, but viability gets treated as important in conjunction with this idea of an undue burden. And that's the Casey case from 1992. So Casey overrules part of Roe v. Wade itself, but it replaces it with this new standard. So Casey would be the key standard that would get limited or interpreted or possibly overruled in the Dobbs case that the court has now.